All right, the floor is yours, Frank. Go ahead.
All right, thanks, JC. So hi, everybody. My name is Frank Danzo, and I'm an elder law and estate planning attorney, and I'm coming up on my 27th year doing this, believe it or not. So I've been teaching this class for Denver community for, gosh, I think it's been about 10 years now or so. And I always enjoy doing it. So today we're going to talk about estate planning and elder law. We're going to talk about all of the issues with wills, trusts, and powers of attorney, which of course, that's the name of the class, wills and trusts. So we use those as tools for part of our planning and stuff, but it's really about planning, okay, and trying to minimize the cost, minimize the hassles, and minimize the problems when something goes wrong, usually in the areas of death, incapacity, disability. So it's never anybody's favorite topic, but it is something that we all face at one time or another. And as with most things in life, it usually goes better if we do a little bit of planning. So today we're going to look at some of the common tools we use. We're going to look at the issues we face in this area. We're going to look at some of the hot topics as well. And I got to find the chat box here so I can open that up, because we're going to want to be able to see that. So if you do have questions, go ahead and put them in the chat box, since we can't raise hands and you're not all standing in front of me like the live ones we used to do a few years ago. So if you do have a question, put it in the chat box. I will try to answer them as I go, and I will certainly save time for questions at the end as well, because it moves pretty fast and there's a lot to cover, okay? So when we talk about this kind of planning, you know, people always ask me, what's the best estate plan you can have? And there's lots of different answers, but somebody once told me the best estate plan you can have is when the last check you write before you die bounces. Okay, so it's kind of cute. It means that you spent everything and even a little bit more before you were gone, right? Because that last check bounced, there wasn't enough to cover it. So you spent it all. Of course, the problem with that plan is we don't know when we're going to pass away, so we don't know when to write the check, right? And if you write it too soon, you're going to run out of money and have to keep on living in retirement. That's one of the biggest fears we have, running out of money in retirement, okay? And so all financial planners and all the banks and credit unions and all the brokerages are like, oh, you want to invest and save so that you don't run out of money in retirement. And then, of course, if you write it too late, you're going to run into a lot of the problems that we're going to talk about today. And so we really want to focus on doing some kind of plan that's not just write that last check and have it bounce, okay? So there are three main problems that we face in this area. They are estate taxes, probate, and incapacity or disability. I'm going to touch on the estate taxes first, because I think it's a pretty short topic today. Although I can tell you, I was just talking to somebody a couple of weeks ago, and I said the estate tax limit has changed 20 times in the 26 years I've been practicing. And it turns out I was wrong. It's actually 21 times in the 26 years that I've been practicing. And of course, they've been talking the last 2 years about changing it again. And 3 proposals did not get approved last year, changing it, but they'll probably do something this year would be my guess. Okay, and currently the federal estate tax, which is the tax on everything you own when you pass away, and that's nationwide, the exemption amount as of today is 12.06 million. How many people are over 12.06 million? I cannot see all of your hands, but I can tell you I wouldn't expect to see a lot of hands. In fact, I really wouldn't expect to see any. I'd have to be talking to a Zoom group of about 10,000 people to have one person raise their hand on average, because 99.99% of us are below the $12 million limit, okay? So this tax doesn't affect a ton of people today. However, they've changed the limit, like I said, 21 times since I've been practicing. It's been as low as 600,000. It's been as low as $1 million as recently as 8 years ago. And they proposed twice in the last couple of years to change it back to the million. It's just been shot down so far, okay? If you go over the limit, the tax is 45 to 55%, so it's pretty substantial, okay? Basically 50%. So very substantial tax. And if they change it back to $1 million, you'll know, because there will be a huge outcry because everybody will be over the limit. And because it includes life insurance and everything you own. Okay. So it's a big deal if you're going to be anywhere around the limit. What you want to do is watch the news, because the most common proposals that I've heard over the last few years are 1 million, 3 million, and 5 million. If you're anywhere in any of those ranges, keep an eye out. And if you do go over, you want to be making sure you do some planning. Okay. Colorado currently has no estate tax. Ours expired about 10 years ago, and we have not enacted a new one because of Tabor, our constitutional amendment that says no new tax on the people without a vote. They have not been able to get it even on the ballot, let alone approved, over the last 10 years most of the time. I think it's been downvoted twice, but it doesn't even make the ballot most years. Okay. So we don't have to worry about that in Colorado. And there's only about 12 or 13 states right now that still do have an estate tax. We are not one. All right. Second problem, much more common and much more everybody wants to know about. How do we avoid? And that's probate. Okay. Probate is the process of getting whatever's in your name out of your name when you pass away and getting it wherever it's supposed to go. Okay. It takes place in the county court in the county where you live when you pass away. So it is not a tax. It is not a trap. It is not a trick. It is not the government trying to get you, but it is a government bureaucratic process. And like most of those, it takes time and it costs money. In Colorado, we have what's called simplified probate, which means you probably won't find an easier or cheaper probate anywhere else in the country. Okay. But that said, on average, I do about 50 a year, and it still takes about 12 to 15 months. And it probably runs $10,000 to $12,000 right now for a pretty garden variety probate. If anything goes wrong with creditors, with beneficiaries, with the assets, then it goes up from there, because it takes more time and it costs more money. Okay. There's other places that charge quite a bit more than that, but in general, that's what we handle, and it's going to be in the range somewhere in there. Question, when you say in the county where you live, do you mean the county where the deceased lived or where the beneficiary lives? Yeah, sorry. So it's in the county where you live when you die. Okay. So it's actually the county where you die, but where you're living when you die. And by the way, it's where your residence is. And so we have people not, if you go to the hospital in Vail because you had a car accident, but you live in Denver County, it's going to be in Denver County. It's not going to be technically where you die. It's where you live. The decedent lives. Okay. So good question. So yeah, it takes place in the county where you live when you pass away. And the process is pretty straightforward, but it's pretty extensive too. Okay. And so we're talking about, if you have a will, we submit your will to the judge in the probate court. They look it over, make sure it's valid. If it is, they issue an order appointing your executor, or in Colorado, we call that personal representative. They go out, gather up all your stuff, pay off your debts, and distribute whatever's left according to your will. Okay. If you don't have a will, we do the same thing, but we follow the state statute. And I would not recommend that if at all possible. The Colorado probate code is about 400 pages right now. Pretty extensive. Okay. And if you've ever tried to follow a statute, there's a reason why when you go to see an attorney, they say, oh, I'll give you my legal opinion about what this means. And the reason for that is you can have two different attorneys go and look at the exact same set of statutes and come up with a different answer. Okay. And the reason for that is, if you said, I want the answer to this question, how much money am I going to get if my stepfather passes away? There's going to be about 20 to 30 sections of statute that you have to go look at to determine that answer, because there's sections with definitions of different things, and each section's usually, a paragraph, but it points to other sections, or other sections point to that section. And so at the end of the day, you will cobble together these 20 or 30 statutory sections and say, this is my opinion, this is what this means. Okay. But a different attorney can cobble it together and come up with a different answer. And that's where you end up with, hey, I disagree, I think it's this. If you can't come up with a resolution or an agreement, then guess what you do? You go to court and you say, Your Honor, they think it means this, we think it means that, tell us the answer. Okay. And that's called litigation, which everyone I know hates. And so it's not the thing you want to do. You do not want to leave your stuff open to the interpretation. You want to state clearly who's in charge, who gets everything, how it's supposed to go. Because if you leave it open to the statute, there's a lot of vague, oh, it's equal priority. My kids all have equal priority. Well, it doesn't say who's in charge. They have to agree and they have to not argue about it. Or it can be equal priority of who gets stuff. Well, if we each get a third, who gets the house? Because usually a third is more, the house is one of the bigger assets. It'll be more than a third. And so you can't agree on who gets it. Do we keep it or sell it? Does somebody get it? All of those things. So the idea is to specify as much as you can how you want things to go so that it's not left open to interpretation and there's less for people to argue about. Because one of the big things you'll see with all of this stuff is when somebody passes away and there's money involved, people do weird things and they argue all the time. So you want to take as much of that out of the equation as you can, because it's very difficult to get people to agree on anything anymore, let alone on those really important things when somebody passes away. Okay. So that's probate. Takes place in the county where you live when you pass away. It takes about 12 to 15 months. We follow your will. And if you have one, and I would recommend it, that's the process. All right. Now, most people say, oh, I really want to get around probate or avoid probate. And we'll talk about ways to do that in a minute. But what I want you to understand here, that's the default. Okay. And it's been around for 250 years in this country. It's been around for about 800 years overall since the Statute of Wills in 1244 over in England. We came from the English system of laws. We follow that here. Okay, so it's been here since 1776, and it's been here almost 250 years. And it's going to continue to be the default. It's for an orderly transition of your stuff when the time comes, because not only does the government, of course, want to make sure that your family gets what they're supposed to get, but they also want to get their taxes. They also want to keep your stuff in circulation so that the economy keeps moving. They don't want everything tied up and sitting there, but no one knows who's in charge or who's responsible for it. And so originally, that's what the king wanted 800 years ago. Oh, I want to make sure when I send somebody to collect the taxes that the people who answer the door don't go, oh, we don't know what to do and we can't pay the tax because we're not in charge. So that's why that's the way it is. You'd like to think the government cares about you. Mostly they want to keep your stuff in circulation. Okay, that's what the process is for. The third problem, though, is the one I want to spend a little bit more time on. What determines domiciliation? So domicile is where you live as your primary residence that you have no intention of changing at the present time. That's what that means. Okay, so you can say, oh, my primary residence, and then you can have a vacation residence or a winter residence or something like that. Domicile is your primary residence. You have to pick one. Basically one state that you say, I'm a citizen of this state, and that's your domicile. And that's where you pay taxes, stuff like that. Okay, that's what domicile means. So the third problem is the incapacity or disability issue. And this is basically, hey, what happens if I'm still here, but I can't take care of myself and make good decisions, and I can't take care and manage all my stuff, okay? That's what it means to become incapacitated. And we all face the potential for this at one time or another. When we talk about incapacity, we all, as we get older, are going to have some level of diminished capacity. When you hit 50 years old, you don't move quite as well as you used to. Probably, I would say, actually in your 40s is where you really start to notice it. Then your 50s and every decade thereafter, it just gets worse. And so we're talking about you don't move quite as well as you used to. You don't think quite as fast as you used to. You may not remember things quite as well as you used to. And so we all gradually decline in capacity as we go along. There comes a point somewhere around maybe 60% capacity where we say, look, you can't do it anymore on your own. You don't know what you're doing. You can't remember what you're doing. You can't keep track of everything. You're not getting the bills paid. All these different things that are evidence that, hey, you don't know what you're doing. Okay. Yeah, I'll come back to the comment there in the chat box in a minute. And so It's a really tricky area though, because that gray area of getting down around 60%, it's really hard to pinpoint exactly when that occurs, okay? And the reason for that is usually we look for evidence of this. Oh, is the person incapacitated? Well, they don't eat well and take vitamins and exercise and take care of themselves. Well, that's not the standard because 50% of the population doesn't do that, right? On a daily basis, doesn't matter how old you are. Well, they don't invest well and save money and pay their bills on time. Well, 50% of the population doesn't do that. That's not the standard either, okay? Because half the people don't do a good job of that stuff either. And so when you say, what's the standard? Well, we look at all these different factors, but it's going to come down to some of those things we look at. Plus, are you remembering things? Are you, doing weird things, wandering out, gardening in your pajamas at midnight, wandering into the street, things like that, getting lost and not finding your way home. So there's things that happen, but it's kind of a totality of the circumstances thing. We'll know it when we see it rather than a hard line definition. And so that gray area can be really tricky. If you don't have a plan for this area, it can become a real problem because you can have neighbors, children, adult protective services, the police, social services all get involved, and they start pointing out all the weird things we all do, and they can start saying you don't have capacity anymore. And it can be a real problem if you don't have a plan in place to address it. The default for all of this, if you become incapacitated, is to go to court for guardianship and conservatorship. A guardian takes care of the person, just like a child. A conservator takes care of their assets if they have them. Okay. This process takes place in the same county court where we handle your estate, same probate court, before the same probate judge. As you can imagine, the cost is very similar, except we have two proceedings. We have guardian for you and conservator for your assets. And therefore, it's actually about twice as much. Okay. So if it's 10 to 12 for a pretty average probate, it's about 20 to 25 for a pretty average guardianship conservatorship. Okay. In addition to the cost, we're talking about taking away your right to make your own decisions anymore and giving those to somebody else. Are you going to be happy about that? Most likely not, right? If you've been making your own decisions for 60, 70, 80 years, most likely you're not going to be happy if somebody comes in and says, hey, we're going to take that away from you and give it to somebody else because we don't think you're doing a good job. And so when we talk about this, taking away those rights, who's most likely going to be doing it to you? Your spouse or your kids, okay? Even your spouse does not automatically have the right to do whatever they want with you and all your stuff, okay? Why is that? Well, we're all supposed to be autonomous. We all are individuals. We have our own rights, correct? If you get married, it takes away, gives some rights to your spouse, but not all of them. We also have a 56% divorce rate, which means more than flip of the coin chance that you get married and you're going to be wrong. So if we had your spouse automatically having all those rights, could be a real problem, okay? A lot of people could be in trouble. So spouse is usually the highest priority and then followed by kids, but it's not automatic. They still have to get approved by the court, okay? So what we're really talking about here is a procedure where you get to go to court, spend tens of thousands of dollars to argue with your family about whether you're doing a good job or not. Does it sound like fun? Anybody want to sign up for that? No, right? But that's the default. You're all signed up for it unless you do a plan with something else, okay? Deceased was moved to another state with Alzheimer's. Yes, they probably, if they have Alzheimer's, they get moved to another state, and that's going to be under a guardianship conservatorship. And then you have to transfer it and go through all of that, which can be a real mess, okay? Who has the right to determine whether you're incapacitated? The court. So in Colorado, it's become a real constitutional due process issue. You cannot take away somebody's rights without due process, okay? Just like criminal rights, just like all of that. We can't take away your freedom, can't take away your money, can't take away your rights without due process. And so the whole process of guardianship conservatorship is really a protection for you, but it's just a very cumbersome protection. And there are other ways to make a plan where you pick the same people that are going to end up doing it anyway, or you pick who you want and you don't go to court to do it, okay? Is GRC public record? Yes. It is public record. Probate is public record. Now they've put in some restrictions because they don't want people just randomly searching through all of these, but there are ways to get, it's all public record. Occasionally they will seal one if there's some kind of sensitive issue, but for the vast majority of us, it's public record. Okay. What's an incapacitation plan called? We're going to get to the tools and we're going to get to the plans here in a little bit. But the point of talking about incapacity is you're all saying, okay, well, that sounds terrible, but that's not going to happen to me. That's going to happen to the people in the next class, right? Well, what is the % chance that an adult in the United States is going to become legally incapacitated at some point? Well, depending upon who you talk to, somewhere around that 45 to 55%. Okay, basically flip a coin. That means you or the person next to you, or if we were in a group, in a room, same thing, you or the person next to you. Okay, that's pretty high odds. Flip a coin. Let's put that in perspective for a second. Anybody in here play the Powerball? I usually get a fair number of hands for that. Okay. And yet, what are the chances of winning the Powerball? 1 in 293 million, right? You have a better chance of being struck by lightning twice than winning the Powerball. And they say lightning never strikes twice. Although I did hear the other day, lightning strikes the Empire State Building 20 times a year. And they have some kind of system to deal with that. So I guess it can strike twice, and it can strike if you're the Empire State Building. But as a human being, it's about 1 in 255 million. Okay, you have a better chance of being struck by lightning while you're being eaten by a shark. That's 1 in 268 million. I only point that out because those are super, super small odds. There's about 300 million people in the US. And so the odds are like one out of everybody. Put everybody's name in a hat, draw one name. That's your chance of winning the Powerball. Okay, 1 in 293 million. It's probably not going to happen. And yet, every year or two, we get one of those billion-dollar jackpots. Prizes equal 50% of sales. That means, you know, for the 1.6 billion one a couple of years ago, you had to sell 3.2 billion tickets. That's 10 tickets for every person in the US where you got to be struck by lightning while you're being eaten by a shark in order to win. But apparently everybody's playing the Powerball. So if I said it's a flip of the coin that you're going to become incapacitated, I would assume everybody's got a plan for that, and probably 2 plans, right? Because it's literally probably going to happen. Nope. We know about 70% of people do no planning at all, no estate planning at all. And of the 30% that do, less than half are planning for incapacity, which means somewhere around 10 to 12%. So 88 to 90% of people, 9 out of 10 are not planning for this. And yet it's a flip of the coin. So I bring that up because it really should be pretty high up on the list. The other thing I point out, everybody worries about estate taxes. Everybody worries about probate. Everybody worries, are my kids going to get my stuff? And those are all important things. But guess what? You're not going to be here for any of those. Okay. Guess what you will be here for by definition? Incapacity, because it means you're still alive. You're still here. Right. And so it's embarrassing. It's expensive. It's fighting with your family. It's a miserable experience. And it's a flip of the coin chance that it's going to happen. So that's the whole elder law. When people say, what is elder law? I don't understand. It's mostly around what happens if you're still here, but you can't take care of yourself. Okay. So you really want to make sure your plan has that. And since 90% of plans don't address this, it's a real problem for most people. That's why my partner, Marco Chayette of Chayette and Danzo, does all of that stuff, goes to court every day, does guardianship, conservatorship every day, all day. That's almost all he does. He's the busiest attorney in the state. I mean, it's crazy. And he's certainly, if not the best, then one of the best. And yet that's all he does, because most people, 90%, haven't planned for this. Okay. Is there a form to fill out for guardian and conservator? Yes. So there's different ways to say who you want to do it. What I would usually recommend, though, is that you use some of the tools that we have at our disposal to try to address this without actually going for guardianship and conservatorship, because it's a miserable process. Yeah, you're better off saying, this is who I want to do it, but it's better if you just avoid the process altogether by doing a good plan to plan around it. Okay, so there are 3 main tools that we use in this area, and they are wills, powers of attorney, and trusts. Okay, In general, we'll start with wills. Wills have been around since the statute of wills in 1244, and they have continued in this country for about 250 years. By far, the most common planning tool you'll see is I did a will, okay? It's been the way since before I started. It's the way it is today, okay? Probably anybody who's done any planning in that 30%, they've almost all done wills, okay? Will does two main things. It says who you want to be in charge, who you want to be executor, or as I said, we call it personal representative here in Colorado. And then it says, where does your stuff go? Okay, who gets what do they get? Who are the beneficiaries? What do they get? If you have minor kids, it'll say who the guardian is for them, but the vast majority, like 98% of people, do not do their will while they have minor kids. It's pretty rare. So most of the time that doesn't come into play. Okay, and obviously a car accident when your kids are minors, that's pretty small chance. So really your will does those two main things, okay? Does your will avoid probate? No, right? In fact, your will is part of the probate process. Your will is the instructions to the judge in the probate court on what to do, and you have to submit the will to the judge to make sure it's valid, and then the judge has to appoint your executor or personal representative, okay? Does the will appoint your personal representative? No, right? I just described that. The will nominates who you want. The judge actually appoints them, okay? How many wills can you have during your lifetime? As many as you want, okay? Which one are we going to look at? The last one you write before you pass away, because that's the one we know you can't change anymore, okay? So wills are a good tool because they do help put less for people to argue about, but they're not necessarily the best tool because they still go to probate and you still have to go through the process, okay? So I do recommend having a will, but sometimes we build the plan with more tools than just the one, and we do other things. Second tool that's very common is power of attorney, okay? Power of attorney is a document where you give someone the power to act on your behalf. They become your agent. Very similar to a real estate agent or a sports agent or an entertainment agent or somebody like that, okay? The most common powers of attorney that I deal with in this area are a financial power of attorney, who's in charge and what do we do to take care of your stuff, and a medical power of attorney, who's in charge and what do we do to take care of you. You can give those powers and say, I want those two, okay? Now, the most common ones in general, you can do a general power. I give you the power to do anything I can do. By the way, you can only do legal things with the power of attorney. So you cannot rob a bank and then when the police show up, say, oh, go arrest that person over there because I was robbing the bank for them as their agent, okay? Cannot do that. You can only do legal things with the power of attorney. But you can have a general one that says you can do anything I can do. Of course, that's kind of a blank check and that's extremely risky. So you better really trust your agent if you're doing something like that. Or you can give a specific one, specific power of attorney. The most common example of that is a specific real estate power of attorney. If you're going out of town and you're not going to be able to get to the closing for the sale of your house for whatever reason, and you want to make sure the closing goes through, you can give someone a specific power of attorney that says you can sign my name for this one purpose on this one day for this one closing, and then it's gone after that. That's the only time. And that would be the most common example of a specific power, okay? But the ones I deal with, medical and financial powers, are the most common in the estate and trust and elder law area, because those are the two most common things we need help with, okay? And it usually encompasses pretty much all the powers into one or the other that you would have in a general power. But a lot of times people have separate people in charge because someone can be really good at making emotional medical decisions and not so good at managing money, right? And those don't necessarily go together. And so sometimes one person's better at money, paying bills, managing it, making sure it's tracked and done right. And the other person's better at health decisions, you know, making sure you take your medicines, keep all the doctor's appointments square, you get everything you need and stuff like that. So a lot of times it's a different skill set anyway, which is why most people break them down that way, okay? So medical and financial powers. The other element of these that's pretty commonly misunderstood is you can have an immediate power of attorney. As soon as you sign it, your agent has the power. Or you can have a springing power of attorney that springs into effect or comes into effect upon some condition, like when I become incapacitated, okay? How many people think immediate power of attorney is the way to go? Okay, I'm going to tell you, I've asked that question probably 1,000 times. I very rarely get someone to raise their hand, maybe one, I can count them on one or two hands. Okay, how many people think springing power of attorney is the way to go? That's what the majority of people, there we go, got a couple little hands raising there. So the majority of people who do think, pick a choice there, think springing power is the way to go. Okay, but I can tell you, I've done about 7,500 powers of attorney in my career, and I've only done 2 springing powers of attorney. And both times I told people I don't recommend this, and I made them really put it in the file. I didn't recommend this, and I tried to tell them not to do it. Why do you think that is? What happens when you walk into a bank and you hand them a springing power of attorney and you say, it's an emergency, I've got to get the money to pay the bills? What does the bank say? Well, they're going to say, it says right here, this is a springing power, okay? This power of attorney is only effective upon the incapacity of the person is the most common language. So it has no effect unless the person's incapacitated. How do we prove incapacity in the state of Colorado? I'll give you a hint. We already talked about it. It's called guardianship and conservatorship. So when springing powers came out about 15, 20 years ago, right out of the textbooks, the hot new thing, people are like, oh, this is a great idea. They don't need it unless I'm actually incapacitated. The problem is, to prove the condition requires you to go get the court order. And that proof is a lot more expensive and a lot more cumbersome than it was 20 years ago. In addition to that, you've also got other problems with the springing powers, right? And it gets into, okay, if you say, I don't trust my agent right now, I don't want them to have the power right now because I'm afraid that they might, what? Take all your stuff, steal all your stuff, right? I don't want them to have it right now because I don't know if I trust them to access everything right now. Well, if you don't trust your agent, I would argue you shouldn't be giving them power of attorney in the first place, okay? Either power of attorney is not the right tool because it's too much of a blank check, or that's not the right person. You should be picking somebody else, okay? So springing powers, you run into all kinds of stuff. You got to have proof. You got to get around HIPAA. HIPAA is the medical privacy law. It says the only person entitled to get your medical information is you, not your spouse, not your kids, not your friends, not your family. So when you're trying to activate these things, plus it takes anywhere from 6 weeks to 6 months to go get the letter from the doctor. If you're going to try to activate them and only get a doctor's letter, it takes about 6 weeks to 6 months to do that. Okay, because doctors are busy. They don't like doing these things due to the liability, and you have all the HIPAA problems you run into. And so it takes a long time to get somebody diagnosed. Oh, the doctor says we think they're incapacitated, therefore this springs into effect. So what do I recommend with regard to powers of attorney? I recommend you pick somebody you trust, you give them an immediate power of attorney that's in effect as soon as you sign it, and then you keep it in your possession because they can't run around and do stuff with it unless they actually have it. They got to show it to people and say, hey, I'm the agent, I'm the power of attorney, I want to do this for them. You have to show the power of attorney, okay? And they can't run around and do stuff if they don't have it. So if you pick somebody you trust, the chance of them breaking into your safe or your safe deposit box to go get it should be pretty small. And since the chance of incapacity is like flip a coin, and we don't want to spend tens of thousands of dollars in 6 months running around trying to activate all this, it's a lot more practical to do it that way, okay? You can argue about it, but that's what I recommend when we talk about this. Okay, a couple questions on POAs. What happens if a POA was filed in one state, but not the domiciled state? So yeah, this gets into, you want to make sure that your POAs match where you're going to be, okay? So if you have a POA from California and you moved here, you need to update your POAs. Okay, because if you walk into a Colorado bank or a Colorado hospital with a California POA, you're going to have a hard time. You might be able to get it to work, but you do that over and over, you're going to run into problems. They're going to say, I don't know what California statutes, they're going to be all over the place in the document. We don't know what those California statutes are. They got crazy stuff out there. We don't know. Okay, I don't know because I can only keep up with Colorado. So I can tell you it'll be a problem. And so if you move, you want it up to date. Now, if you say I'm going fishing in Florida, or I'm going golfing in Arizona, and I'm going to be down there, and you have a heart attack or a car accident or something, they'll still work because we know you're coming back to Colorado eventually. And so we'll get you back here and we'll sort it out, even if you're gone for a couple of weeks and something bad happens. But if you move somewhere permanently, and it's one thing to say, you know, I go down to Arizona for 3 months during the winter, you're still coming back. So it's going to work out in the long run, most likely. But if you move to Arizona or you move to Florida and you're never coming back, it's going to be a problem. Okay. And that happens a fair amount. You get tired of winter. We're about to get another blizzard here in an hour or two, and it's another foot of snow. And you get older, you don't want to do anymore. That's where you see the snowbirds, or you see people, I'm retiring, where it's warmer. Okay. So if you move, you do want to update. Can you have a combination of a spring POA and immediate? You don't really have a combination. You either have the power or you don't. And if you put a condition, you have to activate the condition and prove it in order to have it work. And so you pick one or the other. I recommend immediate, especially on medical. There's no way to abuse a medical power of attorney, because as far as I know, I don't believe in voodoo. So we can't do stuff to you without you being there. Okay. Which means you can't abuse a medical power, because if they're like, give them an injection, cut off their leg, or do whatever. Well, we can't do that to you without you being there. And so the only time that's going to come into effect is if you don't know what you're doing anymore, or you're unconscious. And we want it to work at that point so your agent can do what they're supposed to do. Financial power, there's a little bit of risk, but like I said, if you don't trust your agent, you shouldn't be giving them any power. You know, I had a lady a few years, hey, I got a springing power and I waited 8 years. You finally had a stroke. Now I can go steal everything. Like, it doesn't necessarily protect you to put a springing power. If the person's going to be a crook, they're going to be a crook. Okay. And so you shouldn't be giving that power out in the first place to somebody who isn't going to do the right thing. Are both springing and immediate powers filed with the courts? So generally, powers of attorney are not filed with the courts or any other public record. They could become part of that if something's going on, but it usually takes pretty bad circumstances to do that. I can tell you the one thing that they do get filed is if you're selling real estate, we have the statute of frauds, which means everything has to be in writing. And if you're signing for somebody else, they have to show why you have the authority to sign for somebody else. And so the power of attorney would get recorded for that purpose for the closing. Okay. And that would become public record. But otherwise, you really don't, end up doing that. Let's see here. You were incapacitated when you moved. Yeah. If you're incapacitated when you move, unfortunately, the POA is probably not going to be enough. It might work for a little while, but if it gets bad enough, you can't do stuff, and you're in a memory facility with Alzheimer's or something like that, we're probably going to end up, you've got to have a guardianship anyway, because you can't lock somebody down in one of those memory units where they can't wander off into the street. You can't lock somebody up without a guardianship. It just doesn't work. So you can be in an assisted living and you can say, oh, I'm here and I kind of know what I'm doing, but I need help, even in a nursing home, but you can't put them in a lockdown memory unit without really a guardianship. It's very difficult to do because they can't lock the door on you and restrict you. It's either kidnapping or, something worse, false imprisonment, stuff like that. All right. Can I appoint a POA that resides in a different state than me? Yes, that part's okay. Most of the things that a POA is going to do anymore, you can do it by phone, fax, FedEx, email, you name it, online, all of that, right? And so, yeah, they'll probably come see you to make sure things get set up correctly, but you can have someone living in a different state. As long as you trust them to do the job, anybody in the continental US, probably okay. All right. It's who you trust. You're not going to pick your next door neighbor to be POA just because they're the closest people to you, right? It's who do you trust? At the same time, if you pick somebody in the jungle in Africa where they can't communicate, or you pick somebody in China that's halfway around the world and the time zones are always going to be messed up, and it's hard to, they're asleep when you're awake and vice versa, and they can't get a hold of anybody, that could be a problem. You could do it, but that could be a problem. But certainly anybody in the continental US, it's only an hour or two from here either way, so no big deal. Okay. That works fine. So that's kind of how powers of attorney work. Third tool I want to touch on, and then we're going to start running out of time, and I'll open it up for questions, and that's trusts. Okay. Trusts are certainly not right for everybody. but they are becoming more and more popular all the time. When I started 26 years ago, trusts were kind of in the middle point where they started becoming popular about 50 years ago. And by the time 25 years ago or so, they were sort of becoming popular, but you could still make arguments either way. Over the last 25 years, they've continued to grow in popularity more and more and more. And the reason for that is a trust is a private contract, and it allows you to create a plan that says who's in charge and what do we do to take care of me and take care of all my assets if I can't do it for myself, either because I've passed away or because I've become incapacitated. And so if you think about that, that's a pretty powerful tool for addressing a lot of the things that we do in this area, okay? Very powerful tool. So I'll get into more of how it works with that, but I'm going to kind of give you a little background history on trusts. So trusts are actually, even though people think they're the hot new thing, they've actually been around longer than wills. Wills have been around for about 800 years. Trusts have been around since the Romans, about 2,000 years ago. Okay, so they're actually the older thing. It's just that we came from the English system of laws, not the Roman system. Okay, and so they've been around for a long time. The most famous trust in the world, Shakespeare set one up in the 1600s, still going on today. It's got over $1 billion in it. The most famous one, of course, is the King's Trust in England. The King's Trust has probably over $1 trillion in it, probably more now with everything inflating away here. So trillions of dollars in it, includes Buckingham Palace, the Crown Jewels, all the different estates in England, all the castles and all the dukeships and things like that. Those are all owned by the King's Trust. And the beneficiaries of that trust are the royal family. If you're born into the royal family, then you get one of these titles and you get that estate and you get to be in charge of all that and you get to use all of these assets. And then it continues to pass down in the family lines. That's the beneficiaries of the trust. So that's probably the most famous one, okay? And it's been going on for about 800 years. So in general, trust can be for the ultra wealthy, the Rockefellers, the Kennedys, the Trumps, and whoever else you want to say are the ultra wealthy these days, the Jeff Bezos and whoever, right? But they can also be a valuable tool for the rest of us because they help address all of these basic issues that we all need help with, even if we don't have giant estates, even if we don't have tax issues, even if we don't need giant asset protection stuff, which a lot of trusts are for. The most common type of trust is what we call revocable living trust, okay? Revocable living trust means it's revocable. You can revoke it, amend it, or change it whenever you want. You can put your stuff in today, you could pull it out tomorrow. So you're not giving up any control when you have a revocable trust, okay? As opposed to an irrevocable trust, which is irrevocable. You cannot revoke it, amend it, or change it once you set it up. And you cannot get your stuff back once you put it in. Once you put it in, you've given it up. You've lost control of it. You can't get it back, okay? And so only about 5 or 10% of all trusts are irrevocable because most people don't want that. They don't want to give up control. If you are giving up control, it's usually because you're getting some other big benefit back. And so the most common ones I see, irrevocable life insurance trusts for life insurance protection, Medicaid qualifying trust so you can qualify for Medicaid, or asset protection trust so you can avoid creditors seizing your assets if you have some kind of risky profession or something like that. So most trusts revocable, okay? Living trust means you create it while you're alive so that you can actually benefit from it, as opposed to a testamentary trust. So up until about 30, 40 years ago, the most common type of trust was testamentary trust, which is created out of your last will and testament after you're gone. The problem with the testamentary trust, of course, is wills have to go through probate and you have to be deceased in order for it to go into effect, which means you can't benefit from it. And it goes through probate, which takes time and costs money. So nowadays, revocable living trust is the most common because you can actually benefit from it. So it really helps with the elder law issues that we're facing, in addition to the probate issues and what happens to our stuff when we pass away. Okay, so revocable living trust, great tool for avoiding probate, because if you put your stuff in the trust, when you pass away, there's nothing in your name. We don't have to go to probate to get it out of your name. Okay, Great tool for managing assets if I become incapacitated, because it has specific instructions who takes over, who's managing the assets if I can't do it. And it has instructions, use the assets to take care of me. So about 95% of the time, unless we're having, severe Alzheimer's and we're in the memory lockdown where we have to go get a guardianship, you don't need guardianship conservatorship because we've already covered how to take care of me, how to take care of the assets. So we don't need those things appointed by the court. Okay. Trust is also a great tool for protecting beneficiaries from themselves, spouses, spendthrift, alcohol, drugs, business failure, bankruptcy, foreclosure, all the different things the kids run into, especially with the economy becoming more volatile. Every time it swings up and down, people get wiped out, and all kinds of bad things can happen beyond even the car accidents, which of course are on every billboard, TV commercial, radio commercial, and whatever. Have you been injured? The personal liability and all of that. So all of those things can be protected with a trust by putting it in trust for your beneficiary, kids, grandkids, whoever. Okay. All right, let's see here. I saw a couple of questions on the trusts. Late question, what make a will and a pour over will? What's the difference between a will and a pour over will? So yeah, a regular will, you're saying who's in charge and what's going to happen to my stuff when I pass away. You're doing that with a pour over will, but a pour over will says it goes with a trust and says anything that I forgot to put in the bucket, catch it and pour it over into the bucket when I pass away. So it's not ideal, but if something falls out of the bucket and it's not protected, it's kind of a safety net that catches it, pours it over and puts it in. Wills still go through probate, so that's not the best way to do things, but you're better to have the safety net than not. We want to make sure everything is covered. So when we do planning, we have all the different tools, wills, powers of attorney, trusts, a lot of times in the same package, and they may all point to each other and refer to each other, but we have to cover all the scenarios, okay? So you can't take your stuff out of your revocable living trust. Yeah, you can. So revocable living trust, you can take your stuff out. You're still in charge. You're not giving up any control. And you can put stuff in today, pull it out tomorrow. You can spend your money whenever you want. You can sell your house and buy a new house. You can do all of those things. It's irrevocable trusts where you would lose that control. Most people don't like that, so they don't do irrevocable trusts. Okay. Can you file a will in any state? You only file the will in the state where you die and in the county where you die. Okay. So they don't take wills anymore beforehand because they're all the metro counties around town here have giant warehouses full of old wills that they can't get rid of by state law. And people have changed their will 12 times and then moved to Florida. And so they don't want that anymore. So they only take your will now. You can only file it with a death certificate. You have to do that. They've changed the law on that. Okay. Why have a will if you have a trust? Like I was talking about, it's a backup. It is designed to catch anything that's not in your trust. If it was by accident or you didn't get a chance to or whatever, we want that safety net. I would say 90+% of the time we don't use the will for anything and it's just wasted paper, but it's still part of the plan just in case. About 10% of the time we do have to use it, and you'd rather have it than not. What do you have to have? What do you have to state in your will, if anything, to make it a pour over will? So a pour over will is just going to say whatever I own when I die, put it in my trust. Okay, that's why it's called a pour over will. And how do you file your will if you don't know who you are? How can you file your will if you don't know who you are? So yeah, you wouldn't file your will. We only file your will when you're deceased. The personal representative would file it, and they have to have a death certificate to go with it. Okay. All right, so that kind of covers trusts. They're good tools for a lot of this stuff. Does a will need to be notarized? A will does need to be notarized. I would generally recommend that you follow all of the procedures for your will and do it correctly. It should have 2 witnesses and be notarized here in Colorado. There are different requirements you can try to get away with. You can do a holographic will and it does not have to be witnessed or notarized. It just has to be written in your own handwriting and signed and dated. Okay, but it has to be all in your own handwriting. I don't recommend any of those things. Do it yourself, holographic, written, or anything else, because you don't know the language and you don't know what you're writing and you don't know what you're leaving out, and you're going to make mistakes and you're going to end up in litigation arguing in the probate court about what you meant to do, what you actually did, and whatever. I see that all the time. People come in with Quicken Lawyer, with LegalZoom, and they've handwritten stuff. They all get it wrong, and it's just going to create arguments between the beneficiaries that they're going to have to duke it out in court. So I do not recommend doing it that way. Where can you get a basic will, no assets but one home no one wants? So yeah, I mean, I recommend you go to somebody. That's one of the reasons I teach the class, is I recommend you go see somebody who knows what they're doing and get it done correctly. When you're doing wills, they can usually come into a couple $100, $200-300 range to get a will done. All the different documents. Sometimes they're as low as $150 to $200 a document, depending upon how many I'm doing in the package. Sometimes they're a couple hundred, sometimes as high as maybe 300, 350, something like that. So it's pretty inexpensive to get a will and powers of attorney done correctly, and you will save tens of thousands of dollars on court costs, tens of thousands of dollars on litigation versus trying to not have one or trying to do it incorrectly. And so that's what I would recommend. It's very similar nowadays. I don't try to change the oil in my car anymore. I don't try to change my own brake pads. I used to do all that when I was younger and when cars were simpler, but it's gotten so complicated now. I open up the hood. I don't even know what I'm looking at. I can barely find the windshield washer fluid thing, let alone the dipstick to check the oil. It's just, and there's all kinds of whirring, moving parts that I don't know what they are. And a lot of stuff's hidden underneath and all this other stuff. So, it's the same thing. I go to somebody who knows what they're doing now and let them do it. They can do it faster, cheaper, and easier. And I'm not voiding the warranty and messing it up. Okay. Does a memorandum of trust that's filed stand if you've changed your trust? So a memorandum of trust is just writing down the terms. So you're going to want to have some kind of trust agreement or memorandum of trust. We call it a trust agreement here in Colorado. Other places, they may have a memorandum of trust. You're going to want it to have all the terms you want in there. Whatever you don't put in there, we fall back to the restatement of trust and the trust code, which again can be 400 pages for the trust code and thousands of pages for the restatement of trust. Okay. And so if you've changed your trust, you should change in writing what it is and put an amendment to it and say, this is what I've amended, or I'm restating it with the new terms of whatever I want. Okay. All right. I've got a few minutes left. It looks like about 5 minutes. I can open it up for general questions. Anything else that I didn't cover or any questions that were unclear? What if you didn't change the memorandum of trust? If you didn't change it, then the terms are the terms and they're still sitting there. Okay. All right. Before everybody drops off, I am going to tell you, as part of coming to the class today, and JC will go over all this. It's in the materials. You've got materials involved. You can reach out to me. There are materials you can download, organizing your legal affairs. You also each have the chance to do a consultation with me, and basically at no charge, sit down for about a half an hour, go through all the individual things that I talked about and how they apply to your situation on an individual basis. Okay. So you can reach out by email. You can fill out one of the forms you'll see in the materials. You can go to our website, or you can call into the phone number, any of those. And you're entitled to, as part of coming to the class today, to talk to me. Usually we do them by Zoom or phone now, but you get about 20-30 minutes and we can go through your individual situation. If you don't have a plan, what the issues are, what the options are to address it. If you do have a plan, is it still doing what you want? Do you need to update it? Stuff like that. So it's a great opportunity to get a second opinion. If you do have a plan, make sure it's going correctly, or get a plan if you don't have one. At the end of the 30 minutes, I will tell you what the issues are, what the options are, what the costs are to do a plan, and the different options so you can try to address this. And if you don't want to do anything, it doesn't cost you anything. If you do want to do it, you know exactly what it is. It's usually a flat fee, so you know exactly what it's going to cost. And we're pretty reasonable. We have upper mid-range fees, extremely high quality. That's what we've won. You'll see in the materials. I've got over 40 different awards now over the last 26 years. A lot of them for 10 years in a row, stuff like that. So it's a good opportunity to go somebody who knows what they're doing, does it efficiently, does it well, and you can get your plan set up at a reasonable cost. Okay. All right. Let me see if there's any other questions. Thank you. Thank you. Contact info. There you go. It's all up there. Ballpark, what do simple trusts cost? So when I'm doing trusts, the most simple trusts that I do are somewhere in the 1,500 to 4,500 range, somewhere in there, depending upon what we're doing, depending upon what's involved with assets, family, spouses, things like that. We do a plan. It's usually got a trust package, usually has about 10 to 15 documents in it. And so, it usually comes into the $150, $200 range, something like that, depending upon what we're doing in total. Okay. You're welcome. You're welcome. Single mom, thank you for this. I feel a lot more confident. You are welcome. Okay. All right. Any other questions? If not, you guys are free to go. Thank you for coming. I enjoyed getting the chance to talk to you today. Hopefully you learned some stuff. Have a great week. And like I said, if you want some help, let us know. Okay. Memorandum of trust stands even though you changed your trust. So if you've changed your trust, you have to put a new memorandum of understanding with what you changed. That's what I keep saying, Belinda. So you want to make sure a change means you did it in writing. If you didn't put it in writing, you didn't change your trust. Okay. What if you didn't, then you didn't change it. You need to change it. You need to put something in writing, and that's an amendment or a new memorandum or something like that. Okay. All right. I think that probably covers it. We're running out of time here. So you guys have a great week. And like I said, look forward to visiting with you if you want to. Okay. One more question here. Clarify what's the cost. So most of the trust packages are somewhere in the 1,500 to 4,500 range. I would say the most common is 2,500 to 3,500, somewhere in there. Individual documents, when we do the package, if there's 15 documents and it's 3,500, that's a couple $100 a document, somewhere in that range. That's what we're saying, something like that. Okay. All right. Everybody have a good week, and we will look forward to seeing some of you in the future. Thanks, JC.
Thanks, Frank. We appreciate your time today. I will hang out here for a couple extra minutes till we do hit 1 for everyone to grab that contact information there. If you guys do have any other questions, I'll hang out for these next few minutes. I'm going to go ahead and stop that recording as well. And thank you so much to everyone who attended today. We appreciate your time.
Okay, you're welcome.